everyone. As you can tell, we're in a new set for the new year, and I'm really excited to have with me Phillip Aleke. Phillip Aleke is a very well-known, renowned arbitrator, litigator. He's been in practice longer than probably most of us have been alive. And I'm saying that in the nicest possible way, Phillip. He is a renowned name in arbitration circles, in commercial disputes. And I thought he would be the perfect guest, as he's here in Kenya at the moment, to talk to us about his experience in his work in his life and how he made it, basically. Everything that we want to know here at Njeri Talks. So Phillip, very, very welcome. And thank you so much for agreeing to do this.
It's a pleasure. It's very kind of you to ask me to come in.
No, I am the one who's honored. I'm really honored to have you. I want to start with, first of all, the name Aleke.
Yes.
Because I always say Aleka, but
Yes.
it's Aleke.
Yes.
Thank you for correcting me. You told me that it means chief trouble
Correct.
You're from Uganda.
Yeah, absolutely.
A lot
right.
of people think that you're actually Kenyan, but
I
you're
am.
not. Well, I guess it's
My soul is.
Okay. So tell us about where you come from, how you transitioned from Uganda to Kenya.
Yeah.
A bit of your background.
Well, I mean, going back to your initial question about the name,
Yeah.
Aleke is the correct pronunciation. And
Okay.
it breaks down to chief trouble, Care being a chief in Acholi, and Ali being trouble. And my father was born at a time when my grandfather was a chief, was having trouble.
Yeah.
So that's how that came about. But to your second question about coming to Kenya, probably quite traumatic, actually. Being brought up in Uganda, where I was born, wonderful life, completely idyllic.
In northern Uganda or
I was in Kampala, and I was actually
okay.
born in Kampala. So,
Yeah.
so in fact, my first language in Uganda would be Luganda,
Okay.
even though I don't actually speak it particularly well. I, happy, as I was saying, idyllic life up until Idi Amin came along.
Yeah.
And we were actually his immediate next door neighbors in
Gosh.
Uganda. So that was very traumatic.
Was that before he was, I guess, president or
Well,
after?
yes, it was actually.
Okay.
It was when he was head of the army.
Okay.
And so literally we were adjoining properties. And so the night that he overthrew the government, we had his soldiers who were lying on his flat roof, strafing the top of our house. So I remember my father coming and grabbing me off because I slept on the top bunk with my twin brother, pulled me off. And that was the beginning of quite an interesting time. I won't go into the details of the day, but as a result of my father being pursued by Idi Amin, we came to Kenya to live.
Yeah.
And that was interesting because, of course, my father had been to university and actually schooled in some instances with a lot of Kenyans. There wasn't a university in Kenya at the time. So
There was a Makerere.
it was Makerere.
Yeah.
So the likes of Duncan Degwa,
Yeah.
the likes of Geoffrey Karithi, Taita Towet, Duncan Degwa, Samaruhu, all these people he went to university with. And they made it a softer landing than it otherwise would have been.
Yeah.
So we were refugees. And so that was quite interesting. So he came to Kenya, settled really well, and the rest is history.
Okay.
I could spend a long time telling you about that transition, but I won't.
Okay. But the thing I also learned is that you are a twin.
I am indeed. Yeah,
Okay.
I am indeed. Yeah.
Where is the other twin?
The other twin is in Oklahoma.
Oh, wow.
So yeah.
Okay,
So we're
nice.
fraternal, don't look alike
Okay.
at all, and no interests.
All right. And not a lawyer either.
No, he's not.
Okay.
No, he's not. No, he's not. He's done a number of things, and I
Okay.
think he's still trying. So yeah.
Interesting. Okay, fine. So you come to Kenya.
Yes.
You then go to university in Leeds.
Yeah, so I actually have, chronologically, I went to
Yeah.
Lenana School, which for
Okay.
me was absolutely formative. I mean, before that, I went to Turi. Wonderful, wonderful time at
Okay, so I
Lenana.
went to
Made
Turi as well.
Right, and made the best friends at school. I then, yes, went to university in America. At the time, it was all the rage. A lot of my contemporaries.
Okay, so university in America first.
Yes, indeed.
Okay.
Yeah. So I went to Vanderbilt University in
Okay.
Nashville, where I did a 4-year degree in economics and politics.
And at that stage, did you know that you wanted to do law, or was it?
Yeah, I always thought
Yeah.
I wanted to be a lawyer.
Yeah.
But I did consider doing development economics.
Okay.
And actually, I was offered the opportunity to do a PhD. Actually, it was really quite an interesting story because I was taking a very basic economics, a class in microeconomics. And it was a very difficult class because it was taught using indifference curves. And I struggled with this. And I went and found myself a PhD student from India. And he was brilliant. And he told me exactly how to do these indifference curves. I never went to any of the lectures. I'd show up, I'd see the test. indifference curves.
And know how to
I'd
do it.
absolutely ace it and walk out, and everybody else was there for the rest of the time wondering how to get through it. And it was through that actually that I was offered the opportunity to do it. But actually I really enjoyed it. You see, it was a connection.
My dad's an economist, so I can tell you I've grown up listening a lot, and definitely put me off doing anything like that. Okay, so when you say that you wanted to be a lawyer, why? What was the interest?
I think like a lot of lawyers, idealism. I think my background and my experience having to leave Uganda had something to do with that. But actually I had wanted to be a lawyer before that. Actually for as long as I can remember, I always sort of thought I would enjoy
But did you think of yourself as more of a human rights type, defending innocent people, criminal?
I wasn't quite sure, and I think this is one of the things that I think if I were to give anybody advice, I think if you can zero in on something in the law, if you want to be a lawyer, zero in on something that you really want to do, you're that much further ahead in terms of developing your career. No, I didn't know what sort of law I wanted to do. And so that was part of the process actually of as a lawyer, working out what areas you had a particular strength in. Yeah.
So after the 4 years, you then go to Leeds and do the law degree.
Yeah, that's correct. While I was at Leeds, actually, a professor from Leeds University, a Professor Hogan, who anyone who's done law would have read Hogan's criminal law.
Probably,
So Professor Hogan was at Vanderbilt, and he said to me, apply to Leeds. So I ended up going to Leeds, where I did a full 3-year degree. And of course, for Americans, law degrees are always second degrees.
Correct.
They're not first degree. So I wasn't really out of kilter. I mean, I could have done law as a first degree, but I didn't. So I did the full law degree.
Yeah. So after that, you obviously decided on a path in law.
Yes.
But I guess you could have done a solicitor, barrister.
Correct. Yeah.
And you decided on the barrister
Yes,
route.
exactly.
Okay.
Yeah.
So you joined the Inner Temple.
Correct.
And from there,
yes.
what kind of practice did you want? Well, what set did you join?
Interesting. And 1990 was actually when I was called to the bar, and it was the middle of a recession. It was very, very difficult. Actually, my ideal was coming back to Kenya to work. Uganda wasn't an option because at the time, if you remember, there were real problems, and I couldn't or wouldn't be admitted at the Kenya School of Law because I was a Ugandan. Strangely enough, now everybody gets admitted. It's not a problem. We have a slightly
not everybody,
no, but yes, we have a slightly different attitude. So my default position was to go back to England. Actually, I also thought about going back to America, but I then started in a general common law set, doing everything, crime, matrimonial, the whole lot, which was really good experience in terms of advocacy, picking up different subjects and becoming competent at them. But gradually I began to zero in on sort of contractual work, civil contractual work, commercial work, because I actually had an affinity for it. I enjoyed it, and actually I thought I was quite good at it.
Yeah. What were you like as a junior lawyer? Because I can't ever imagine you being intimidated or shy behind the curtain type, because you have to really put yourself out there if you're going to be a barrister, isn't it?
Well, you know what? The first case I ever did, the first time I was on my feet in court, was in the magistrate's court. And I was defending somebody who'd been prosecuted for driving whilst disqualified. And not having done my research thoroughly enough, I actually thought I could get him off. Well, he went to jail for 6 months. And so I acquired the name Maximum Phil. That was my first experience.
That is hilarious.
I was consumed with fear at the time, standing up in court. And I realized actually at that stage that unless I overcame my fear, I wasn't going to get anywhere. And so that was the end of my butterflies. Now I go up in court and I just, I'm in my element. I enjoy it.
Maximum Phil, I love it.
Exactly,
I love it.
I've never been able to live that one down.
Yeah. So contractual disputes, it's a commercial, essentially it's a commercial dispute. It's someone who has come into an agreement, they've disagreed, and now you're there to fulfill that role.
Absolutely. I mean, sorry.
Go ahead.
No, I was just going to say, contracts come in all varieties, don't they? And they all involve all kinds of subject matter, from ships to aeroplanes to banks to insurance companies. But they're all fundamentally the same principles. And you don't often you don't really need to understand the subject matter. Some of them have peculiarities with which you need to be familiar. For example, I do international construction law, which itself is quite a specialism. I came to that a little later, but I was doing much more contractual work, and I felt that I needed to go back and do that. So at some point in time, I came back and did some
so you're saying, we do know that contractual disputes come up because of the fact that the contract has gone wrong, the parties have misunderstood each other. What special skill do you think as a litigator you brought to dispute resolution for your clients?
Well, I think technical competence in in contractual work and just an aptitude for contract, for seeing variations. You know, people talk about contracts and it's an offer and it's acceptance
Yes.
and it's consideration, but there are all sorts of other little bells and whistles and wrinkles that actually can help one to achieve contractual enforcement. And it's those sorts of things that I really enjoy and have enjoyed exploring. So I wouldn't say that I'm necessarily unique in terms of what I give my clients, but I do feel that I have an aptitude for contracts. But I think the other thing also is that interest in contracts was something that I brought with me to arbitration.
Yeah.
Because of course an arbitration is contractual. It's parties that agree as a matter of contract, but in the event of them being in a dispute, they will go to an arbitrator or an arbitration panel for the resolution of their disputes.
Yeah.
So
How did you come into the arbitration space then, from the dispute resolution space? Because obviously the Arbitration Act for the UK only came into force in the middle of the 90s, I think. And so it wasn't actually something. Now it's much more prevalent, but at the time it was very nascent.
Yeah. Actually, Njeri, I don't really agree with that. I mean, England has always been the epicenter for the law, and arbitration has been. Arbitrations have been conducted in London for many, many years. The 96 Act was a relatively recent act. Actually, the Kenya Act is 1995, England 1996.
Yeah.
But it was interesting. While I was practicing in England, I began to see my English colleagues actually excelling. And it was a little disconcerting. The law and the success that one makes in the law, one's path in the law, is often influenced by one's contacts.
Yes.
How often you get instructed. And I was beginning to recognize that actually, as an East African, as an African lawyer, it wasn't really happening for me. And I became very introspective, and I looked at myself, and I almost did a SWOT analysis on myself, and I said, look, what is it that you need to do to try to make a real go of this? I mean, I remember talking to my wife, and we were looking at my figures one year, and she said, Philip, this isn't going to happen, And so I thought, let's think about this. And it's at that point that I really began to focus on leveraging my background as an East African in London. I was seeing contracts, arbitration contracts, big disputes, big commercial disputes coming to English lawyers who knew nothing about East Africa. Why was it that they were getting this work? Why was it that I couldn't get this work? What did I need to do to put myself in a position to actually get the work? And it's at that stage I had an epiphany. I said, look, I'm going to go and I'm going to do a formal course in arbitration. I mean, this was in 2000, 2003. And that's what I did. And it was completely transformative. It also, by the way, coincided with the upturn in GDP and growth and development in East Africa. Absolutely.
Yeah. I mean, you've barely scratched the surface on the fact that there is, and even I experienced it, discrimination in terms of your ability to excel in legal practice if you're based in the UK and you're not from the UK, because obviously protect ourselves first. And obviously the fact that you're from East Africa and you're an outsider. How did you deal with that in being in younger practice? What were the real tangible things that you could feel that others were not feeling?
Well, it's a really, really good question, actually. Thanks. I remember going into an interview. I got a call from somebody and they said, wow, you've got a fantastic CV. Why did you come in and see us? I walked into the room and you should have seen the look on their faces. I mean, it was apparent to me. I hadn't said a word other than perhaps good afternoon. And it was that sort of thing back in the late 80s, early 90s that one encountered. It's very, very different now. And so, the whole question of discrimination or prejudice. I mean, and you get it sometimes. I've had it sometimes in front of judges. Where I mean, this is not a criticism, it's a cultural thing. It's really different. I mean, I have a daughter who's a lawyer. I mentor a huge number of East African lawyers. I see now how young people who have the opportunity to go abroad, once they finish, they're embraced by international law firms, there's space for them, they're everywhere. And I mentor many of them. Sometimes just sitting with somebody, and talking to them, having lunch with them, having supper with them, saying, listening to them, articulating their thoughts about where they want to go. I mean, that's one of the things that I do as a way almost to make up for what I didn't have, which was seriously,
but that is absolutely true. I would say that when I was a trainee, I was the only, Black person. I was the only African person in the law firm that I was in. So I can't say that, I hope that it's changed a lot more, but certainly I was the only trainee who was African and Black in the firm. So yeah, I can definitely see that for you, it must have been much, much harder. Can you give us an incident that you can remember and how you dealt with it so that we can paint a picture for everyone who is not in the fortunate position not to have
in
the sort of way that you feel as if whatever I do and because it's me that's in front of the person, I'm never going to be able to be successful, and it's not because of your skill.
I've never thought that.
Okay.
I've never ever thought that, and I think if you ever had that thought, you'd be in big trouble.
Yeah.
I've never actually thought that. I've always sought to persuade people and convince people of my ability, my competence. It's incredible that the whole range of things. As I gave you one example of walking into an office, you've been in front of judges who've not listened to you, and you've wondered why. Is it people correcting you or trying to correct you, your language occasionally. I mean, I remember one judge said to me, we were in the habit of saying, I would do this. And the judge said, you would you? As if to say, well, that's the wrong tense. And I say, yes, I would, I have, I would, I do, and I have. And he laughed. So, I got, and things, two alternatives. And I said, well, no, it's duplication. But they're little things, subtleties, in a very English way that people sort
But the point is that if someone else who is not from your background or even from our background does not have to do as much persuasion, right?
Yeah.
Or did not have to do as much persuasion in order to excel.
Yes.
Anyway, let's move on.
Be positive.
Because it's a topic that we can go on for.
Absolutely.
But let's focus. So you decided, let me do international arbitration.
Yes.
And now, what is that? What does that look like for you?
Well, I mean,
what did it look like at the beginning?
Well, at the beginning, I was ahead of the curve actually on that, and I was really pleased about that.
Okay.
So that introspection, wondering how I could leverage my position, all of that works. Of course, it's been picked up all over the world. And now, I mean, we have a lot of international arbitrators who are African, established senior arbitrators, those coming up. The world of arbitration has changed. In part, actually, it's unfortunate because it's been prompted in many respects because the courts have not worked as efficiently as they should.
Yeah.
But arbitration itself is a consensual process. As I said, it's contractual, but it's underpinned by the courts. So, when there's a problem in the arbitration process, you end up having to go back to the courts. So if you have problems in the courts, delay, corruption, and there is, sadly to say, not in England, I hasten to add, no, seriously, but in other parts of the world, then it's an issue. So and actually, I think even sometimes there's a concern about arbitrators. I mean, arbitrators themselves are challenged and have been found to have behaved improperly. Sometimes it's completely unjustified. There is a question of conduct. I mean, for example, I was very concerned about the question of integrity in arbitration. In Kenya specifically. And that provided the motivation for me to introduce a work program in the UNCITRAL, which is the United Nations Commission for International Trade Law, essentially providing for codes of conduct that were applicable to judges and to neutrals, because it seemed to me a completely unregulated area that just couldn't be left to the parties to self-police. And so, it's contractual, it's consensual. There is some cohesion, but it seems to me that it still needs to be regulated.
So if we just break it down, if you are a party to a contract, and you have chosen an arbitration clause in that contract, you then are subject to whatever arbitration you've decided to go with in that contract. Fine, we're together on that. When you look at choosing the arbitrator, that would probably be led by either the dispute resolution clause or by the rules of the arbitration.
Correct.
You choose the arbitrator, and then if I look at the UNCITRAL that you just mentioned, where does that come in?
Well, it's interesting. I mean, I always look at it because the contract is the fundamental piece of the puzzle. Oh, I say piece of the puzzle. It's the foundation. It's the substratum on which you do everything else. And some arbitration clauses will have what they call that will apply, make provision for an institution.
Correct.
to regulate the arbitration, but it'll also apply for institutional rules to apply, or rules to apply. And it's those rules that are superimposed and form part of that, contract. But also behind that then is the law of the arbitration. It can actually get really, really complicated because, I mean, potentially in any arbitration, I mean, this is getting really technical, but in any arbitration, you could actually have 4 laws that apply.
Yeah, because if you're looking at, for example, a dispute in construction, which is now your expertise, there may be rules that are the legal rules for the construction in that country or that jurisdiction. And then you're looking at the arbitration rules to govern the dispute, but underpinned by that is then the law of the actual dispute itself.
Absolutely right. I mean, you've got the law of the place, the law of the seat of the arbitration. The arbitration will be based on everything. And then you've got the law of the contract, which may itself be different. So, for example, you've got a contract between a Kenyan and an Indonesian, and they'll provide for arbitration in London. So the contract between the two parties would be, say, let's say, Indonesian law, say, or Kenyan law. But then, because the arbitration is in London, you would have English law applying to the arbitration process. It's that sort of thing that creates some interesting conflict of laws.
I mean, that's complex enough. But I also want to just make sure that we all are on the same page in terms of if there is a dispute on the arbitration itself. Is it that you can only dispute the process of the arbitration, but not actually the grounds on which the decision was made? Is that correct?
That's generally right, and the reason for that is the New York Convention, which limits the basis on which you can challenge an arbitration award. It's only on very limited grounds. That the whole point of it is to have a binding award at the end of the process. This it's not a court process. You don't want to keep going back to court and appealing. So it is actually very, very limited in terms of the way you can challenge it. But it's interesting how disgruntled parties can be very ingenious in terms of trying to discover ways of bringing themselves within one of the limited categories. I mean, I've done some quite interesting cases.
So let's get into that, because I really want to get into, giving the audience an idea of the type of work that you do, so that, anyone who's interested and anyone who wants to get into arbitration or is in arbitration can get a feel for it. So tell us, because you do disputes that involve states as well as individuals. So how does that marriage, unhappy marriage, work?
Well, Njeri, this is absolutely right. I mean, international arbitration is I suppose you could say there are sort of 2 broad species. I mean, there's commercial or sort of private international law disputes, and then there are disputes that involve states, and of course states have special rights that go with that. But also in that sphere of arbitration, there's quite a lot of administrative law, because what you'll find is the disputes in which states are involved is where they've given concessions for mining or the construction of special projects. But there's all kinds of licensing and government regulatory considerations that go into that sort of work. So it's important to have an understanding of that particular area. And also, you've got quite a lot of supranational type of rules. I mean, in international state disputes, you don't necessarily have a national law that applies. I mean, it would apply to some things, but not everything. And public international law issues are quite different from private international law issues. So interesting. I mean, I had a dispute once. I was acting for an Asian government, and actually, although it was a state party, it was under the private international rules, under UNCITRAL rules. But that's again a slightly different situation that sort of sits, if you like, right on that, on the cusp, if you like, between what would be a quintessential, state investor-state arbitration and a private international dispute involving state considerations. But a fascinating case. It involved a concession for a lignite mine.
For a what?
A lignite coal mine.
A coal mine.
In the middle of a jungle in Asia. And
did you get to see it?
No, I didn't. I didn't. But the investor invested huge amounts of money, first of all on exploration, then having identified that there were huge quantities of lignite, actually then having to deal with the local warlords, the warring factions, which actually included getting military intervention to clear the area, to safeguard it, and building roads and all this sort of thing. So really quite interesting, because ultimately what happened was there was an allegation that that concession was expropriated. In other words, the government took it away.
When the investor had already done the work to clear.
Yes, when quite a lot of work, exactly.
Yeah.
And so he brought a claim, which was essentially a contractual claim for compensation.
Yeah.
And part of the claim included the amount of money that he had spent
doing
all this preliminary work.
Yeah.
You know, it was absolutely fascinating.
Okay.
A decision in Kuala Lumpur, actually.
Okay.
Yeah, but had international consequences, because the award was then enforced in London, in New York, in Paris, in Singapore as well.
And was it successful?
We were successful, I hasten to add. We were successful. Actually, it was quite an interesting case. And I mean, you know, again, there's quite technical, but there's a rule in private international law, certainly English private international law, that where a court makes a decision, that decision cannot be disputed in another court until the court that has made that decision sets it aside. So in this case, there was enforcement. The investor was looking for enforcement of an award because he won at first instance. So he was looking to set aside the award. So he got enforcement in New York. And then they came to London, where I was acting, and then they went to Singapore. They went to Malaysia and then to Singapore.
Yeah.
But we in London couldn't actually resist the enforcement because there was the New York award that was binding on the London court.
Okay.
So it was almost like the dominoes had fallen one way, and what you had to do was have them fall the other way to eventually get to your particular jurisdiction. So
of course, if that is the case, then you could be jurisdiction shopping.
Well, people do forum shop.
I'm sure.
Yeah, they do.
Because then it's easier for you to then get an enforced award.
Absolutely right.
Yeah.
And you're absolutely right, because in that particular case, the government actually chose to go in Paris, which was very, very quick.
Yeah.
And in Paris, they set aside the award, which meant that in London, we could say, that's absolutely right.
Gosh, these things do get complicated.
They do get complicated.
At this stage, because of you're so well known and revered, I guess, in this
that's very kind of you, but I'm not sure.
Philip, come on. How do you get an instruction? How do people get you? Do you have to do a lot of marketing? Do you do no marketing at all? I mean, obviously the advertising rules, etc.
Yeah. No, I think there is a lot of word of mouth.
Yeah.
There's a lot of reputation. I have to say to you that I think the best marketing tool is pursuing excellence.
Yeah.
You know, given the opportunity. Well, first of all, being technically competent and excelling and doing well if you're going to do arbitration, if you do an arbitration course, doing well at it. But then when the opportunity comes along, it's actually doing well. It's demonstrating to the parties, demonstrating to the arbitral institution, and if you've got co-arbitrators, demonstrating to them that you're completely and utterly on top of your work.
Yeah.
I mean, it means a lot of hard work, but that's the best marketing tool.
Yeah.
The rest is sort of peripheral in the sense that you go to conferences, you write articles to demonstrate your competence, but it's not quite the same thing as seeing somebody actually in action. That, it seems to me, is the key.
A side question, but a relevant one nonetheless.
Yeah.
Because the UK has always been the seat of dispute resolution for everyone globally, and the reputation of the English courts has been so strong. Do you think Brexit has made a difference? Because there was that question as to whether Brexit would then affect whether people want to be in the UK or go to Germany or other jurisdictions to look for a solution to their dispute.
Yeah, I don't think, frankly, that Brexit has had any effect on arbitration. There are so many, there are contracts. Mind you, this is the thing. I mean, there are contracts that are being performed all the time, and they would have put their dispute resolution clauses in years ago.
Yeah, years ago, yeah.
So I haven't seen a falling off. And in fact, I think because the English courts are so well known for being such fair places for the resolution of disputes and efficient places for the resolution of disputes, where you've got great institutions, you've got competent counsel, you've got great judges, that it will always be a place where people want to go. And that's one of the things we in this jurisdiction in Kenya, Uganda, East Africa, we have to work on our courts, the efficiency of our courts, 7 years, 8 years for a case to go to appeal. It's just completely unacceptable. It used to be that, not quite that bad, but it used to take a long time in England. And England realized that it was its comparative advantage. Its edge was speed. So they did a whole reform of the English law and commercial laws to try to ensure that everything progressed speedily. And that has paid dividends. And, unless we look at the infrastructure, it seems to me we're going to continue to be giving our work away.
What for anyone who's listening, who's a young person looking to do dispute resolution or in dispute resolution now, can you go straight into arbitration, or do you need the years of dispute resolution experience first?
No, you can go straight into arbitration if that's what you know what you do. I think most people don't actually know what they want to do, and that's the problem. And I mentioned this previously, that you don't necessarily know. I mean, as I said, I went through this introspection working out arbitration. But the sooner a young person can identify which particular area of the law they want to get into, the more they can begin to develop their relationships and build connections, start writing articles, paying more attention, because the law is vast. There are so many different areas. So you don't have to. What you really have to decide is, if you want to do investor state, if you want to do private international. As a young person, if you want to get experience in arbitration, you can work with an established arbitrator. You can work with some of the institutions. That's a really good way of getting experience. I was in Washington, D.C. in September last year. I found young Kenyans working in ICSID, which is the International Center for the Settlement of Investment Disputes, which is the World Bank institution for the resolution of investor state. But you've got the LCIA, you've got the ICC. All these institutions offer young people the opportunity, and actually by working inside, you get to see the internal workings, how the institutions operate, and you get to see how counsel work, and it's a really good way of getting good experience early on.
What would you say is the highlight of your career so far? What has been one of the highlights? One of the highlights, I guess. Could be several. I've had many, but I think for me, one of the I don't suppose it was a highlight, but it was recognition, was when the president of the World Bank appointed me to his panel of conciliators and arbitrators, which was back in 2017. And I mean, there are only, I think, 24 lawyers from around the world that are appointed. So we are the default panel to whom the president comes for appointment when states or a state and investor cannot between themselves agree. And it actually came for me at a time when I was facing some criticism, actually. Really?
Personally, which was completely unwarranted, by the way. But it was such a vote of confidence in me, and that was quite. I felt quite pleased and complimented by that. I don't know what I did to deserve it, but I did.
Probably a lot of good work, Philip.
Well, I was really quite pleased by that. Okay. And yes, I mean, I've had lots and lots of successes. One of the things that I've always said is one never wants to rest on one's laurels. You never want to feel that you've always achieved. There's so much more to achieve and to do. So yes. Yeah.
And if there's someone out there feeling disappointed, having a hard time, it can be very, disconcerting when you're facing a dispute. None of the parties want to agree. You can't even get a resolution. What advice would you give to them?
Always keep your head up. Always.
How do you do that?
Just by
physically putting your head up.
Just by being optimistic. I mean, my run in the law has been full of challenges. I mean, I mentioned again the introspection I had, wondering, where things were going to change for me. But you've really got to remain positive. You've got to remain focused. But what you've got to do is you've got to concentrate on your technical competence. Because if you can do the work, if you can do the work, the opportunity will come along, and you'll be able to shine. And people will see it. Putting yourself out, volunteering, looking for opportunities, being proactive in terms of finding opportunities, not being discouraged, not letting people discourage you, is really important. There are many opportunities, and if you want to achieve, if you want to succeed, if you're persistent, you will ultimately succeed.
Dealing with high pressure situations when you're in front of two parties, warring parties, how do you deal with that? What is your advice on dealing with high pressure situations?
Preparation. Preparation, I say it 3 times, is more. I, sitting as an arbitrator, will make sure that I know the case before me better than the lawyers.
How long does that take?
It takes a very long time.
Yeah.
It takes a long time, and people sometimes look at the bill, the hours that have gone in, and they sort of wonder. But you've got to know the case better than the parties, because you've got to make a decision. They are hiring you. They are appointing you. They have appointed you. The institution has appointed you to get to the right answer.
Yeah.
I have not yet sat in on arbitration where the lawyers have actually covered everything. I think probably.
What do you mean by that?
They don't find all. They don't pick up all the important points.
Okay.
I mean, I in most arbitrations that I do, I, through my own research and effort, come up with the answer.
Yeah.
And I mean, that's a surprise. And I think it does depend on the sorts of lawyers that are in front of you.
Yeah.
In some jurisdictions, I find that it's routine. It's 100%. I've never had the lawyers come up with the right answers. I mean, I find it's less true for example in England. Honestly, in fairness, because I think the rigor with which lawyers in that jurisdiction, but it does happen a lot.
Yeah.
It does happen a lot. So I would say 100% outside England, probably 60% in England.
I mean, that's such a shame. But I would say that when you're talking about the right answer, I'm assuming that you mean the getting to the heart of where the dispute lies, and then interpreting that. Yeah. Or the misalignment in where that misinterpretation has happened.
Identifying the issues. Identifying the issues. Yes.
How much does the drafting of the underlying documentation, so the contract, affect the way in which an arbitration can go? So I guess we're looking at both the drafting and the ambiguity there, and then also then whether the parties understand exactly what they were signing themselves up for.
Right. Are we talking about the arbitration clause itself?
No,
or are we talking about the substantive contract?
The entire contract,
Well, I mean, of course, the substantive contract determines everything.
Yeah.
And you're right. I mean, some contracts are a complete mess. Sometimes the parties, at the time of drafting, their lawyers haven't really given full consideration to the implications of certain things within the contract, and it's the job of the arbitrator or a judge actually in courts to try to interpret exactly what the parties and looking at the objective meaning. What do the parties, knowing what they knew at the time, reasonably think? I say think. It's an objective test. It's not a subjective test. I mean, what would a reasonable person have thought that they would think about what they were agreeing at the time? So that's
So looking back now and looking forward as well. What do you want to? What is your message to the world in terms of what have you achieved and what are you proud of, and then what are you looking forward to in the future?
That's a very big question.
It is a very big question.
It's a very big question. I mean, I would hesitate before I dare to say anything to the world. But I mean, for me...
No, because I guess the world is your audience, right?
Well, I mean, for me, what I would like to see is I'd like to see discipline within the law in East Africa. That means discipline within the judiciary. Judges are the guardians of our rights. And it's absolutely essential. If there's no law and order, Thomas Hobbes said this: man is by nature evil. We come together and form a social contract. We give up certain privileges, the right for me to beat you over the head, and similarly, your right to take my property, to live together in harmony. And if we can't rely on judges to make the right decisions and uphold the law, if that process is subverted, then we're finished. But it's not the judges alone, because judges were once lawyers, and it's the lawyers also who need to stop and consider the greater good, the importance of being officers of the court, upholding the rule of law. Lawyers now are unscrupulous. It's the Wild West. There's so much indiscipline. It's really quite sad. And actually, in my view, it's a heresy, because if you're undermining the rule of law, you're actually undermining the Constitution. You're undermining the people of these great republics. Yeah. And you're not giving us a fair chance. I can't do that on my own. I do my best as a community, we know those who are engaged in conduct that we wouldn't want encouraged. But it's so pervasive.
Yeah.
And it's for me, it's a really, really big concern.
Yeah.
And if I was to say something, I would say to colleagues. I mean, I'm now old enough. I mean, there are 2 Supreme Court judges. I was looking at this. there are 2 Supreme Court judges in Kenya that I'm older than. I mean, I've been in the law for that long now, which with all due respect to their lordships. But I feel that there's a certain entitlement I have, given my seniority, to be able to say the things that I have to say, and that for me is the really big.
Do you think you're saying it loud enough in the right forum?
Well, I'm trying.
Yeah.
I'm trying very hard to persuade people to do the right. I mean, I understand business, for example. People can be sharp.
No, of course.
Yeah, but I think when it comes to the law, what we have is, it's a vocation. What we have decided, what we're doing, what we should be doing, is within the law, protecting the rights of our compatriots.
Yeah.
And building that institution so it has strength.
I mean, absolutely. Nothing that you say is going to be foreign to anyone in this audience. So absolutely.
No, that's right.
And for the future?
Right. For me, for all of us, well, I'm going to try and help younger people. I mean, that for me is my big thing. I as I say, I mentor a lot, but I go out and I try to be an ambassador.
Mm-hmm.
I try to be an ambassador for you asked me, am I a Kenyan or Ugandan? I'm both. Actually, my heart is
East Africa, I guess.
Well, my heart is
Uganda.
Kenyan. It's Kenyan.
Which one? Kenyan.
Yeah,
Okay.
yeah.
Mm-hmm.
Funnily enough, I was talking to a politician the other day who was educated in Uganda, and we were sitting at the bar talking, having a bit of a love-in, and I said to him, I said, I have a confession to make. He said, what? I said, Kenya's in my heart, even though I was born in Uganda.
Well, your Kikuyu is certainly better than mine.
He said to me, Uganda's in my heart. No, I'm Kenyan. So it's these things are they're bits of paper. But for the future, bringing young people up, supporting young people, understanding and appreciating that young people are a future.
Yeah.
And that for me is really, really, really important.
Yeah. You've got 4 daughters.
I do.
And all of them will be lawyers at some point.
No sons. I have one lawyer at the
one
moment.
lawyer.
I don't know what the other 2 are going to do. They're still I have 1 doctor, 1 lawyer.
Oh, 1 doctor already.
Okay. Yeah, absolutely. Right. Well, she's the eldest, so she's an orthopedic surgeon. Then I have a lawyer, and then I have 2 who are still at school. So,
amazing.
Yeah.
Well, Philip, it's been lovely having you.
Thank you very much.
It's been lovely.
Indeed.
I think we've learned a lot, and thank you so much for taking the time.
Thank you.
I want to go through the quick fire round, and then I'll let you go.
Right.
Quick fire.
Yes.
Did you read the questions or not?
I have seen some of your questions actually.
Well, I hope
I haven't got answers to
memorize the answer. Beach or city holiday? And
definitely beach.
Where?
Mombasa.
Definitely.
Yes.
Favorite place to visit?
Mombasa.
Seriously?
Yeah.
The whole world?
Yeah.
Okay. Apple or orange?
Orange. Definitely.
Flat
citrus.
or sparkling?
Flat.
Favorite song to listen to?
I've got many favorite songs, but one of my favorite songs is a song by Rush. It's called Marathon. I know actually it's extraordinary. It's a song that an American guy introduced to me, but it's a philosophy on life, on the marathon of life.
I'm gonna have to
listen
listen to it.
Well, it's terrible to listen to. I've only found 1 Kenyan. I was shocked about this. I was talking to somebody asked me the same question. And he said he said he loved the song as well.
Gosh, let me try and find it.
I've got lots and lots of really good songs, but that's one that I have on my Apple Watch. I run to. So it's good. It's good.
Pizza topping of choice.
I'm not a pizza person, but pepperoni if I had to.
If you have to.
Yeah.
Favorite drink?
Oh, I love water.
Really?
Yeah,
no one's ever said water. I don't think.
No, I don't drink actually. I stopped drinking a couple of years ago.
Oh wow!
So,
how has that been?
It's quite good actually.
Yeah.
It's quite good.
I'm doing dry January, so
right.
It ends soon.
Right.
Yeah.
Yeah.
All right. Thank you so much, Philip. You've been an amazing guest, and I think your wealth of knowledge is, surpasses definitely mine. But obviously, you can impart a lot of knowledge to younger people, and I hope you continue to do that.
Well, thank you very much indeed for asking me. I mean, it's quite difficult, these sort of interactions.
Why? You made it look easy.
Well, I hope it makes sense when we see it. But thank you so much for asking me. It's been a pleasure to be here.
Everyone, take care of yourself. See you next month.
Goodbye, everybody.